Hi, Robert Bonavito here, New Jersey forensic accountant. Today we're going to talk about pro se litigation, which means you're representing yourself in court. This is a pretty interesting video because it actually was a unique situation I had where I was basically forced to represent myself in court because it was a very sensitive issue involving Harvard University, one of the most powerful entities in the United States. And a lot of the bigger law firms were reluctant to take a case against Harvard. But the reason it's referred to as one of the greatest victories in the last 50 years is because if you look at this case, it was litigated in the following courts: New Jersey Superior Court, United States District Court, New Jersey, before two federal judges, United States Court of Appeals for the Third Circuit, United States District Court for Massachusetts, Massachusetts Judicial Conduct Proceedings, Massachusetts Petition for Review of Judicial Conduct Proceedings, United States Court of Appeals for the First Circuit, possibly the Supreme Court. And here's an article that appeared in many of the leading newspapers written by Lisa Hayes in Illinois, Belleville, Illinois, wherever that is. But what the article basically gives you a good summary of what happened. Harvard loses. New Jersey federal judges advance consumer fraud action. Judge Michael A. Shipp of New Jersey District Court ruled on June 30th, 2021 that Harvard's motion to dismiss is denied. Denied. And remember, Harvard had 3 or 4 major law firms helping them with the case, and it was just me, no lawyers. Robert Bonavito, a pro se plaintiff, prevailed over the defendant, Harvard University, who entered this litigation with a hoard of cash, $50 billion, and a phalanx of the country's top lawyers. Harvard was outmaneuvered by a tough and persistent underdog pro se plaintiff. And then this interview they did with me kind of gives you a good understanding of the whole lawsuit. Bonavito said, "The policies at the country's top universities tend to reflect power relationships among major social groups. This power relationship has resulted in current policies at Harvard that have a strong discrimination bias based on age, gender, and race. This lawsuit will put an end to that discrimination once and for all." Many people in the legal community consider this case to be one of the most important discrimination cases since Brown versus the Board of Education, Topeka, which stopped racial segregation in public school system. The whole case really revolved around my classes that I took, graduate classes up at Harvard University. This is an official transcript from Harvard University that shows that I've taken all the courses, passed them all. I think I had like a 2.6 or 3.7 GPA. And that's why if this ever went to trial, Harvard would lose because they have nothing to stand on. This is the credential, if you guys can see it, that Harvard was fighting about. And you can see that I did eventually retain it and was pretty happy with that. Even though we didn't get everything, I was successful in getting this. It cost me about $13 million, and that's pro se without attorneys to get this this credential you see in my hand. So let's talk about some of the things as a pro se litigant, not only this case, but you're going to have to understand and go through. Now, first of all, pro se, it just means it means on your own behalf, and it's your federal right. You have a right in the United States as a citizen to represent yourself in court. Of course, the courts aren't set up for that. So let's just look at some statistics on pro se litigation. The first one is going to be the U.S. court system, and the second one is going to be from the University of Chicago. Okay. These are, you can find these for yourself on these below links. Okay, this chart here shows, now let's go to figure 1. This chart basically is how many cases are filed in district court. So total cases about 220,000, and someone where a plaintiff or defendant's pro se is about 75,000. So about 1/3 of cases filed in the federal district court have a pro se litigant, yet the courts aren't set up for pro se litigant. Generally, judges don't like pro se litigants. It's extremely difficult, and that's why they say this case that I was involved in was one of the greatest victories ever, because the odds were stacked against me. And if you do look at some of the other statistics here, you can see like most of the pro se litigants have to do with prisoners. Okay, a lot is civil rights, which this case kind of falls into that category, but most of the pro se litigants are prisoners. And then if you look at the cases by type again, this is for pro se litigants filed by non-prisoners. It's mainly civil rights, and again, that's kind of where my case fell. And if you look at the other website, which is the study by the University of Chicago, you could see that for civil rights cases, pro se litigants only win 2% of the time, and pro se plaintiffs. 18% of the time you have counsel, which means there's 11,000%, 1,000% more chance that you win if you have counsel. And again, that's why this case was so surprising. So let's say, again, the court system is really not. A lot of judges don't like pro se litigants because they feel that they clog the court system and stuff like that. Some of that's true, but mainly the judges are great. All the people, support staff are awesome. It's just that there's a culture there that is not set up to help pro se litigants at all. In fact, the Supreme Court said that you're supposed to help the pro se litigants and look kindly upon their filings and stuff like that. What I found was the opposite. They held me as a pro se litigant to a far higher standard than the attorneys, far higher standard, which was kind of ridiculous, but that's the way it worked. Why would someone want to represent themselves in court? Better understand the legal system. True. Lawyers are too expensive. That's the main reason. Lawyers do not always deliver quality service, which is true. The case is complex, and lawyers may not fully understand critically. Again, this case is super complex. Started in 2016. My fees without any attorneys was over $13 million. With attorneys, it's probably been about $26 million. If the lawyer won't take the case because they risk alienated, this is the main reason I had to do this case on my own. I talked to the top law firms in Massachusetts, and they were like, no way. The case was too simple. They would win, and if they won, they would lose Harvard and the other schools as potential clients. The way they explained it to me, there's a cartel. It's Harvard, the other major universities, Boston University, Massachusetts Institute of Technology, and there's no formal agreement. But if you win a case against Harvard for, I think the damages here were close to $800 million. The other universities are not going to use you. It's not that they're talking about it, but they just say, hey, that law firm represented Bonavito and they won. So they would not take this case at any fee. And the other thing they told me is, listen, Harvard Law School, most of the judges come from Harvard Law School. I found this out after the fact, unfortunately. And you're not going to get a fair trial. I mean, the judges retire, they go work for these schools. You're never going to get a fair trial on this type of situation in Massachusetts. So, the case is simple. Most cases aren't simple, and most people shouldn't represent themselves unless you're in a unique situation like I was. So the best way to learn something, I think, is to immerse yourself in it, and that's why, if you're going to go pro se, you better understand. You maybe go to court, watch what's going on in court. And again, this case here involved one of the most powerful institutions in the United States, Harvard University. So don't take too much from this, but that's why we had to battle it out in all those courts. And again, I've already talked about, why the reasons why you would go pro se and why we went pro se. Some of the facts in this case, it was pretty basic case, pretty simple to understand. They were denying a degree based on age and gender and ethnicity. And if you look at the complaint, which was filed in the New Jersey court system and then moved up to obviously the other court systems, but it basically had a couple counts. The ones we're talking about at the bottom, it had fraud, obviously, negligent misrepresentation, age discrimination, and gender discrimination. The goal of the litigation, obviously we talked a little bit, was to stop the major elite institutions discriminating by age and gender. crucial component of the litigation. They wanted to move the case up to Massachusetts. I didn't want to go to Massachusetts. Preparation for court, I actually did take courses at Harvard, law school courses, to learn how to write briefs, do case law, submit, how to decipher cases, all that kind of stuff. Obviously, I was nowhere near as good as the lawyers they had. They had all Ivy League educated attorneys, but any fair judge would have sided with me. Know your opponent. Obviously, you need to know your opponent. My opponent was tremendously complex and powerful. Hopefully you guys enjoyed this video. If you did, please smash the like button below. Leave any comments. We'll get back to you. The part 2 of this video is going to be on a separate one. It's going to talk about the actual litigation that happened in New Jersey. Thanks a lot.